This is a great turnout, and hopefully we're going to be able to provide you with valuable information. Few housekeeping matters. We're going to keep you on mute mode during the time of the presentation. Towards the end, we're going to open the line for questions and answers, and when you have a question, you can press *6 to ask your question. We will unmute you, and then you can ask your question. Then we will put you back on mute so we can address any concerns. If you can please also put your phones on mute when you're on this call, so we're not going to hear any interference. And when we are ready to call up for questions, we will call you the last 4 digits of your phone number, so you will know you are the one next in line. So let me start with some basic information. As we all know, or maybe some of you are familiar with, the Department of Immigration announced last week on the 9th, September 9th, that they are updating the visa bulletin system. From this coming October, we're going to see 2 different charts when we look at the visa bulletin in trying to determine when we can file the 485 petitions. There are going to be 2 very important dates on the visa bulletin, and that's going to be the date for action and the date for filing the petition. That means that date of action is still the normal, traditional priority date that we have always been concerned about it, the one that we know until my priority date becomes current, I will not be able to file my 485. That's the normal. That's the one that tells us when the Department of Immigration is going to be processing the cases filed at a specific date, so whether or not I'm going to get the green card soon. Then the filing date, which is the change or the new chart, refers to the date that the Department of Immigration is now making available for people to file their I-485 petitions. The filing date is going to be sooner than the final action date, which means, and let me just give you an example to illustrate this point, is if your priority date, for example, is March 1st, 2011, but when we look at the visa bulletin, you see that the filing date is March 1st, 2012, then although the priority date for your green card petition is not up because it's still March 1, 2010, your filing date will be current in terms that you will be able to file your 485 petition. That means that you can file for employment document, travel document, and obtain these benefits what your green card process is pending. Pending to what? Well, pending for the final date of action. That means that the 485 petition might be pending for more than just a few months or a few years, depending as to how soon, and we already know that, how soon the priority date moves along. Just to give some information as general background, because probably some of you are a little bit confused about the priority date and the visa bulletin and how the system works, just let me give you some brief information, and then we can go into more detailed, more specific information. So when we file for a green card, whether it's based on employment or family relative petition, there's a system that determines when people will be able to get the green card. And this is usually called the priority date system, which means that when you file your petitions, the day you file the petition with the Department of Immigration or the Department of Labor, that's for employment-based petitions that need a labor certification, Department of Labor, then the day you file the petition with the Department of Labor becomes your priority date. Or the day you file the petition, I-140, employment-based, with the Department of Immigration becomes your priority date if a labor certification is not needed. For family petitions, then the priority date is the date in which the petition is originally filed, properly filed with the Department of Immigration. Properly filed means Department of Immigration receive all the forms and respective fees, and the people who applied for the benefit qualified, and there were no erroneous filings. So those are the dates that determine the priority date. However, to attach or to make the priority date effective, those petitions have to be approved, meaning when you file the petition for immigrant petition based on employment, whether or not there's a labor certification process required, the I-140 petition has to be approved for the priority date to be established. Same with immediate relative petitions. The I-130 petition, yes, the day it's filed becomes the priority date as long as the I-130 petition is approved. So if you later on get a denial, although you file and you probably thought, oh, I established my priority date, if there's a denial, then there's no priority date established. How do you look at visa bulletin? Well, every month the Department of State releases a visa bulletin, which is some sort of a letter or a chart that shows different countries in the world, specifically the countries that have a backlog or that they have a waiting list, as I tell people, and the rest of the world. The Department of Immigration only has so many visas, green card visas, that they can grant every fiscal year. Fiscal year for immigration purposes, it starts on October 1st and ends September 30th. So every fiscal year, the Department of Immigration only has so many green cards that they can grant to every country in the world. So the way the Department of Immigration and the Department of State go about this is that they give these visas on a percentage basis. And as the visas are granted, the number of visas are less and less until the end of the year when there's no more visas available. Some countries that have a big demand, like India, China, then they have a big waiting list or backlog because there are more visas that are petitioned for than visas available. So the Department of Immigration revises these numbers towards the end of the fiscal year, and sometimes they move the priority days forward or backwards, depending as to whether they exceeded the numbers they were supposed to give or they are running out of visas sooner than they anticipated. So every month, as I mentioned, towards the middle of the month, somewhere between the 10th and the 15th of the month, the Department of State releases the new priority dates, and so people can look up and see when they're going to be able to file the I-485 petitions, or for their pending petitions to be approved, or for the consular processes to go through. The numbers are released with a few weeks in advance. So when I said every month, between the 10th and the 15th, when the numbers are released are for the visas that will be available the following month. So for example, for the month of October, we just got the visa bulletin that was released last week, and it's telling us that in October, many people are going to be able to be filing their 485 because now they have the filing date, although not all of them are going to be able to get the green cards because many of them, although able to file the petition, they're still a little bit behind in terms of obtaining the green card. So there's going to be a little wait there. Every month, again, they update this visa bulletin, and the purpose is to give people enough time to prepare the documentation that is required to file for the green card, for the 485 in this case. So What that means is when the priority date becomes current for a given month, it stays current for the entire month. So I usually tell people to keep in mind this, because our first reaction, and I mean, because we all think alike, is I want my application file on the 1st, because that's the day my priority date is becoming current. Well, the current date is going to be the entire month. So as long as the petition is filed within that month, and granted the priority date, in this case filing days do not retrograde the following month, then you should be okay filing it. In most cases, again, because of the new system, it will not make any difference whether it's filed on the 1st or the 30th, because in many cases people will still have to wait some time before the green card is granted, because there's going to be a backlog. So typical or normal documentation for the 485s are photographs, birth certificates, marriage certificates, medical exams. The marriage and birth certificate is one of those documents that I always tell my clients to start collecting ahead of time, because usually these certificates have to be requested from the home country. And sometimes in some countries, government offices are a little bit slow in producing these documents, so it may take some time to obtain these documents. So those are probably the documents that take the longest to be obtained. The other documentation needed for the 485s or to complete the green card process, most people have it handy. Basically, it's copies of all the immigration petitions ever filed, showing that the person has always been in status, or if it's changed the status in the United States, that there has been no lapse in status. If there are any employment authorization documents, visas, passports, the passport should be current, and we always tell people to take a look at it, make sure they're not expired, and that at least 6 months validity from the time the green card is going to be filed. Photographs, passport photographs, and medical exams. The Department of Immigration has a pretty good website where you can enter your zip code, and the website will show you doctors or physicians that are allowed within your jurisdiction or near you to perform the medical exams. That's in general information about I-485s and also how the priority date visa bulletin system works. I believe I have a couple of questions already. So I'm going to be opening the line for questions, and I'm going to start with a couple of questions that we have received in our office. And one of those questions is, my priority date is May 2010, and I am in EB2 India. When we talk about EB2, what that means, we said that you can obtain green card through either employment-based or family-based. Employment-based goes with the letters EB, and there are different subcategories, EB1, EB2, EB3. EB2 are for individuals with bachelor's degree and 5 years of experience, or master's degrees or higher. So if you are in the EB2 for India and your priority date is May of 2010, yes, you can submit your I-485 petition in October, because the new visa bulletin shows that for October the filing date is going to be July 2011. So you're okay filing the petition. And also the question asks for my son is 20 years old, and he will be turning 21 soon. So will filing the adjustment of status or 485 petition prevent him from aging out? What aging out means is, as you might know, children can benefit from the parents' green card petitions as long as they remain under 21 and unmarried. Once a child turns 21, or if the child gets married, then that child will have to look for other ways to get green card, but not through the parents. So in this case, if this family can file their adjustment of status or I-485 petitions in October, and that means including their son, they will be protected, the child will be protected under the Child Status Protection Act, and because the I-485 is going to be filed before before he turns 21, so he will be able to get the green card with his parents, even if he is 22 at the time the green card goes through. One more question here relates to the process of filing for green card and whether this is going to apply to someone who is in the process of a labor certification. This new visa bulletin or these changes to the visa bulletin applies to everybody, all the different categories, family and employment base. In the family, we have 1, 2, 3, 4, 5 categories. In the family, in the employment, we have the same, 1, 2, 3, 4, 5. All of this new system is for everybody. So when you get your green card, if the filing priority date are current, and if you're from one of the countries that you can file the 485, then you might be able to benefit. What you will need to look at is once you're done with your labor certification process and the I-140 petition is filed and approved, then you will need to look at your priority date and check the visa bulletin to see if the filing date is current, whether or not your priority date is not, so you might be able to file your 485 petition as well. And one more question that we had here is, if my wife, who is a green card holder, files for me, how long this process is going to take? Well, when it comes to relative petitions or family-related petitions, we need to keep in mind that immediate relatives have priority, immediate relatives of U.S. citizens. If I am a U.S. citizen, my spouse, children under 21, and my parents have priority, which means as soon as I file for them, the Department of Immigration is processing the petitions, and it will only take a few months until they go through the petition and normal processing time. Now, after that, then anybody else or everybody else is going to be subject to the priority date. That means children more than 21 years old of U.S. citizens, or married children over 21 years old of U.S. citizens, spouses of U.S. permanent residents. The spouse will be in a waiting list. Depending as to the country, then is the waiting list. As we noted before, for employment-based visas, India and China are pretty much always backlogged or have waiting lists. Same in the family-based petitions. We have countries like, again, China, India, Mexico, that depending as to the category, they're going to be on a waiting list. So I think that depending as to your spouse's country of birth, your waiting list, your waiting time might be or a few months or a couple years or a few years. We will need to know the nationality of your spouse and whether or not she's a legal permanent resident or a U.S. citizen to determine how long your green card process might be. Okay, so now we're going to be calling the 4 digits of your phone number, and then when your number is called, go ahead.
If they have a question, they can press star 6.
Okay, and so remember that when your number is called, and if you have any questions, please press star 6, and we'll call your number so you can ask your question. Any questions?
They press star 6.
Please press star 6. Are we unmuted?
Got it.
Okay, we got a question. First question.
Ends in 6798. Question.
Go ahead, ask your question, please. What is the number?
They hung up. All right, next is 4523. I'm unmuting.
4523, please ask your question.
I have actually I-130 applications pending for my wife, who is currently in Canada, and two of my brothers who are in Pakistan. So what does this change actually mean for my wife and my two brothers back in Pakistan? My wife is in Canada and brothers are in Pakistan. I-130, both of them, like all of them have been filed and they're pending.
They're pending. They have not been approved yet?
I don't believe so, yeah.
Okay, so a couple things. First of all, your wife, she's in Canada. Was she born in Canada?
No, she was born in Pakistan.
So the country of citizenship you will go by is Pakistan, even though she is residing in Canada, okay? And for your brother, same thing. It's going to be Pakistan.
Yeah, same thing.
Because the I-130s are pending, you still don't have a priority date for neither one of them. So you'll have to wait for the I-130s to be approved to be able to establish the priority date. And you should already have an idea as to what the priority dates are going to be. Because when were the I-130 petitions filed?
My brothers, they were filed last year, I believe, somewhere in September this time. And my wife's I-130 was filed last month.
Last month, August.
August, yeah.
August of 2015. So as soon as the petitions are approved, and right now the Department of Immigration is taking about 10 to 12 months to process I-130 petitions. I had cases that have taken longer than 12 months for the Department of Immigration to process the I-130 petitions. So once
because I'm a U.S. citizen, so does that make a difference?
Yes. Well, yes and no. Yes, in terms that the Department of Immigration, for your brothers, it will not make any difference. It's an I-130, it's a relative petition, it's a brother, sibling. So they're going to be in the queue for quite a bit, in the I-130. For your wife, it might save her a few months, but not a lot. I-130 petitions, when they are filed by themselves, unfortunately, the Department of Immigration has a little big of a backlog. So my experience in the last couple of years, even I-130 filed by U.S. citizens, they take about 8 to 10 months to be processed. So don't be surprised that your wife's I-130 petition takes longer than 6 months to be granted. Once it's granted, because it's your wife, she's not going to be subject to a priority date. She's an immediate relative, so she will have priority. Once the I-130 is approved, the Department of Immigration will notify the National Visa Center. They will contact you to pay the fees or fee bills, so you can start the consular process for your wife to immigrate to the United States. So it's a matter of getting the I-130 approved, National Visa Center fees, and get the consular process done. No priority date for her because you are a U.S. citizen. For your brothers, there's a priority date issue because siblings of U.S. citizens do not have priority, and they are the last concerns or the last one in the chart for the Department of Immigration. So you will be looking at their priority date for Pakistan. And I can tell you right now, the Department of Immigration is processing for siblings of U.S. citizens. Right now, they are in February 1st, 2004.
Oh, wow.
So your brothers are going to be looking at somewhere between 10 to 11 years, maybe longer. Remember, the priority dates do not move one day at a time. The Department of Immigration is on the same day for years, no, months, I would say, weeks or months. So for your brothers, there's going to be a long waiting time.
Okay. Makes perfect sense. Yeah, I got it.
Next.
0532.
0532, please ask your question.
Yeah, hi. I have actually two questions. The first question is my husband's green card has been filed, so his priority date is December of 2011. So can we expect the filing date to become current in the next few months? That's the first question. And the second question is, can my application be added to his application at this time?
Okay. Let me, you got me lost on the second question. What do you mean my application can be added to his application?
I am currently in the U.S. on a work permit, and I am doing my J1 waiver process right now, so I'm on an H-1B visa. My green card has not been filed for. So my question is, can my application for a green card be attached to his as a spouse?
Okay, so when you say my husband LPR, I take as his I-140 is approved?
That's correct.
Okay, so his I-140 is approved with a priority date of December 2011.
That's right.
Where is he from?
India.
India. Okay. So regarding your first question, for India, looking at the priority date, October, okay, we see that the final action date for India is going to be in October, May 1st, 2005.
Right.
So right there you can see for purposes of obtaining his green card, he's going to have to wait quite a bit because the action date is May 1st, 2005. However, the filing date for India is going to be in October, July 1st, 2011.
Right.
So if, and one thing that I have been kind of cautioning my clients is that this is a new system. Still need to give the Department of Immigration a few months for us to have an idea how it's going to work. We expect that the filing dates are going to be more consistent than the priority date, final action date. So when the new visa bulletins come out, we expect that the dates are not going to be moving backward or going as they have with the other dates. So if this kind of stays consistent, we do expect that the filing dates for visas are going to be moving forward, not backwards. We also kind of expect that they will move a little bit faster than the normal priority dates. So I think that for your husband that has a priority date of December 2011, he might be able to file his 485 within the next few months, if the July 1st, 2011 filing date moves along consistently. Is the best we can do.
Okay.
Now, regarding your application for green card, yes, you will be able to take advantage of your husband's petition as a dependent, but you mentioned you are in H-1B completing your J-1 waiver. How long have you been in your H-1B in compliance with the J-1 waiver? How many years?
1 year. 1 year. So I have 2 more years to go.
Okay. Once you complete the 2 years, or the 3 years, within the next, after the next 2 years, once you complete the 3 years of your J-1 waiver obligation, and remember, when we are counting the 3 years of J-1 waiver obligation, we need to look at the date you start working. It's not the date the H-1B was approved or the date the H-1B was, but actually the date that you started working. An example is if your H-1B says approved effective September 1st, 2012, but for whatever reason you were not able to start working until September 20th, 2012, then you will start counting those 3 days from September 20th, 2012.
Correct.
Count your 3 years from the start date of your employment, and then at that point, if the filing priority date for your husband's I-140 day action day is current, then you will be able to file your 485 petition under his. We actually have a few clients that we are right now filing I-485 petitions for husbands and wives because they are just completing or they completed the J-1 waivers and their filing priority days had not been current until now. So yes, you will be able to do that when the filing priority day is current.
Correct. And even if the filing priority date is current prior to my completion of the 2 years, I can, after 2 years, apply for the adjustment of status as a dependent.
You cannot file your adjustment of status until you complete your 3 years. 3 years.
Okay.
You have to complete the 3 years to file your adjustment of status. And to file the adjustment of status, the filing priority date will have to be current. If the final action priority date is not current, but the filing priority date, yes, then you file it. But you have to complete your 3 years before you move forward with your 485 petition.
Got it. Okay. All right.
Great.
Thank you.
You're welcome.
Okay. Next caller ending in 0951. Go ahead.
0951. Go ahead.
Yes, actually, I had 2 questions. Actually, I had the priority date of March 2011, and through my previous employer, my I-140 was approved. But then I changed the employer 1 year ago, and now my current employer has filed for I-140, but it's not approved yet, and they're saying that it will be probably approved in November or December. So can I apply for I-485 and can I get EAD?
Okay. Now, let me ask you. Yeah, go ahead.
And my other question was, my husband is on H-1B, and his employer haven't approved. They haven't done the I-140 application process yet, but he also had the priority date from our previous employer, and he also changed his employment 1 year ago. So can he get EAD if I get EAD?
Yeah. Okay. So a couple things here. The I-140s that were approved before, through which you established your priority date, were they filed based upon labor certifications?
Yes.
Okay. Now, do you know if by any chance the previous employer has revoked those I-140s?
No, I don't think so. I don't believe so. I think
Okay. So now, regarding your I-140, the one that is pending, is it based upon a labor certification as well?
Yes.
Okay. So, couple things that you will need to look at. Technically, you could file your 485 based on the I-140 that is approved, both of you. Okay. As long as those I-140s are not revoked, because if they were revoked or withdrawn by the employer, they're no longer good. You still retain your priority date of March 2011. So when the new I-140 is approved for you, they should give you the old priority date because it's yours. Okay?
Okay.
But I would kind of double check, and it's difficult because employers do control the I-140 petition.
Right.
So,
and what if they have revoked the I-140?
Well, then you couldn't use it, not even to file for I-485 because it's no longer valid.
Okay.
That's the consequence of revoking the I-140. Most employers don't do that. And if you left your employer in good terms, probably they didn't. But as long as those I-140 are valid, you could file your I-485 in September. Now, the other option you have, and it's still early, is that you could pay the premium process for the I-140 that is currently pending, get it approved, so it's approved in October, and you can file your 485 based on the new I-140, so that way you can file the I-485 for you and your husband based on the new I-140 that is going to be approved. You still have time. It's September 15. premium processing, they make decisions in 15 days. So you could get it done if you're not sure about whether the other I-140 is still valid.
Right. Okay. Because that
the 85 for your husband based on your I-140. You don't have any J-1 waiver or any other.
No, I actually completed my J-1 waiver. I'm done with 3 years.
How about your husband? Is he subject to that?
Yes, he completed his J-1 waiver too.
So I will, if the I-140s are valid, again, you can file it. If not, premium process the I-140 that you have currently pending, get it approved, file the 485 based on that I-140, and everybody can file employment authorization documents.
Okay. Now, if I get my premium processing done for I-140 and if it gets approved, can my husband also get? Can he submit the I-485 application? How is that going to work?
Absolutely, yes. Yes, he could file the 485 with you as your dependent.
As a dependent.
Yes.
So does he have to go on H-4 visa for that, or he can still remain on H-1B?
So what is going to happen with him is to extend his H-1B beyond the 6 years, he will need a new I-140, or then he will be using his employment document based on the I-485 that he will file in October. One thing I always tell my clients, though, is that if they can keep their statuses, H-4s or H-1s or any of those visas, until they get the green card, is better. That's my recommendation. But if they can and is that not an option, then if he's not able to extend his H-1B beyond the 6 years, he will be able to use an employment authorization document based upon the I-485 that he will have pending, because he will file with you in October.
Okay, because his employer hasn't filed I-140, the new employer.
Yes, yes. So, no, he can file with you in October.
Okay.
Premium process that I-140, so that way you don't have to worry about the first I-140 being revoked or any of those things.
Okay. All right, thank you.
Thank you.
All right, caller ending in 3605. Go ahead.
Hi.
Hi, how are you?
Good, how are you? Thank you for this session. So my question is, I do have an approved I-130 through my husband, who is a permanent resident, and my priority date shows to be September 16, 2014. So depending upon the October bulletin, it looks like I'll be eligible to apply for I-485 this October. Now my question is, how long, or what is the timeline? When can I expect my EAD or the green card, for that matter, and when can I start working on EAD? So what are the timelines for me?
Yes. Now, let me ask you a quick question here again. What did you say is your priority date, September 16, 2014?
Yes.
And your husband is an LPR?
Yes.
Okay. Yes, and you're right. Based on the filing date of the visa bulletin that was just released last week, yes, you're going to be able to file your 485 in October. The Department of when you file your 485, you will file your employment authorization or I-765 petition and travel document or I-131 petition at the same time. Once the Department of Immigration receives these petitions, usually, and I'm very careful these days saying usually, because remember, in October they're going to get many applications. So we might see some delays in terms of the processing of the EADs and travel documents. Right now, the Department of Immigration is taking 90 days to process EADs and travel petitions. However, we might see that they take a little bit longer for the petitions that are going to be filed in October. That's still kind of just to see. We need to wait and see how they're going to do that, because volume is going to be high. Now, let's assume we don't have any delays and you file your petitions and they take the 90 days to process EADs and travel documents, then you'll get your your employment authorization document in about 90 days from the day you file the 485 petition, and you're going to start working immediately. As soon as you get that employment authorization in your hand, you can start working.
So are there any working restrictions on EAD as far as, let's say, because I own my own company where I'm obviously not, handling anything since I'm a non-immigrant. I do have directors. Will I be able to work in my own company on EAD?
Absolutely. And employment, that's one of the greatest benefits with these new changes is that many people like you are going to be able to file the 485s and therefore obtain employment authorization that will allow them to work anywhere, any employment in your own company or with somebody else. Employment authorization documents do not have any restrictions in terms of employers. So you will be able to work in your own company for yourself using your EAD.
Okay, that's perfect. And one last question, please. So when my priority date comes into the category of final election date, what is the estimated timeline then? Let's say, what is the estimated timeline from the final cutoff date to receiving an actual green card?
Okay, it depends. Sometimes the Department of Immigration, if they require additional documentation, and what we have seen is that if they're saying that priority dates are going to be moving along and your final action priority date is going to be becoming current, they might start working on your petition and issue a request for additional evidence if they need more evidence in your case, to have it ready by the time the priority date becomes current. We have seen with the Department of Immigration that many times when the priority date becomes current, people receive the green cards within the month the priority date becomes current. What might affect that is that depending as to the volume, depending as to the number of applications they have for that specific category, country, and other factors, it might take a little bit longer than 30 days to get the green card as long as the priority date remains current. Because it might happen that it's current for 1 month, but it may become unavailable for the following month, so the process will stop. So it's one of those things that it might happen the same month, or it might happen within the next 60, 90 days, or even longer, depending as to how many applications they are filing. But as long as the priority date is current and remains current, it should be only a matter of a couple of months for you to get the green card.
So you are saying there can also be a chance of retrogressing date? Let's say 1 month my date is current, and the next month it might retrogress also depending on the applications, right?
That's the filing date?
The current date.
The filing or the action date?
The final action date.
The final action date, well, there's always the possibility that they retrogress. If you have noticed, priority dates are, to a certain extent, unpredictable in terms that they may retrogress or they may go forward. Yes, today the priority date, the action final day. We're not talking about the filing day because we still don't know how that's going to work in the longer run. But yes, priority dates, final action dates, they can always retrogress.
Okay. I have one last question. So when my I-485 and I-765 will be filed, are they going to be parallel, or will the I-485 application go in first, and then the I-765 will go in with the receipt of I-485? How does it work? Does it go parallel or what?
Are they filed parallel? They're filed together.
They are filed together, yes. You file the petitions together in a bundle. However, each petition has its own process, and processing times, which means that once the Department of Immigration receives the packet with the I-485 and I-765, they go to different routes, and the 485 will be processed in a different queue than the I-765. That's why the I-765 usually take 90 days, and the 485 can take, depending if it is a priority day issue, it can take years, or may take longer, usually about 6 months if there's no priority dates issues. But yes, they are processed in different times and ways.
All right. Thank you so much.
You are welcome. Good luck.
All right, caller ending in 7061.
7061, please.
Go ahead.
Hi. My question is regarding the advanced parole. I wanted to know what the advantages and disadvantages are if you're traveling with the advanced parole.
All right. Well, let me ask you a question here. Do you have a status?
What do you mean by that? I didn't
Hello?
That. Yeah, hello?
Do you have a status? Do you have a visa right now?
Okay, no, I know as of, the statement which came out a week ago, I know that I am eligible to apply for 485 petition. And I was just reading a little bit about it, and that is where I saw what the advanced parole is. So I was just curious about it. That's it.
Okay, well then, the first thing I need to say, just for the sake of being accurate here, is that not because you're able to file an advance parole means that you qualify for an advance parole. If you are here in the United States in a status, for example, for people who have H-1Bs or Ls or some sort of visa, when they file the 485 and can file for advance parole, they will be allowed to, the advance parole is an authorization for people to return to the United States after they leave. But when they come back to the United States, they will be waiting for the green card. There's not going to be a status per se, which means, for example, if I'm in an H-1B visa and I leave the country, I use my advance parole to come back, I will not be in H-1B. I will just be waiting for my green card. Hopefully I'll have my employment authorization that will allow me to work, because if I don't have an authorization to work, then with the advance parole alone, I can't work. One of the things that people find convenient about the advance parole is that if they are using the EAD to work, then they have to have an advance parole if they're traveling outside the United States to return to the United States. Without an advance parole, you will not be able to return to the United States unless you have some sort of visa that will allow you to come back to stay, work, and live in the United States. Now, if you are filing for I-485 based on employment grounds or family grounds, I-130 or I-140, one of the things that you will have to look at before doing anything else is whether if going outside the United States is going to trigger any of the laws that might prevent you from returning to the United States, even if you have an advance parole. So to answer your question, is one of the advantages is that you don't have to apply for a visa to return to the United States, but one of the biggest disadvantages is that once you enter the United States is that you don't have a status. You're just kind of waiting for the green card, and if anything happens to that green card process, the 485, then you will not have a status, because the advance parole doesn't give you anything but the authorization to return to the United States once you leave. Okay. And if you don't have a status, or if you have an I-130 and you didn't have a status before applying for advance parole, I would suggest that you talk to your attorney before using the advance parole if you are given one. Okay. Does that answer your question?
Yes, ma'am, it does.
Great. Thank you.
Thank you.
Okay.
Caller Julio, go ahead.
Hi.
Hi.
Hello, can you hear me?
Yes, we can hear you. Thank you for calling.
Thank you very much. This is Julio. No, thank you for your time and all the great information you are sharing with us.
Thank you.
So,
go ahead.
I am under the EB2 category, and my future employer is almost done with the recruitment process. It is my understanding that my question, I better say that my question is, which is my priority date? The date that the Department of Labor receive the application for the certification, or when USCIS receive the I-140? Which is my priority date?
Okay, great question. Thank you. Yes. When you apply for a green card based on employment, there are two options, or there are two categories. One is petitions filed that require a labor certification, and then the petitions filed that do not require a labor certification.
Okay.
Either way, you end up filing an I-140 petition with the Department of Immigration. Now, when the priority date is established, first of all, the final I-140 has to be approved. That is what determines the establishment of the priority date. However, for those petitions that require a labor certification to be filed, then the priority date will be the date the labor certification petition is filed with the Department of Labor. So, if you have a labor certification, just to give you an example, if you have a labor certification that is filed on October 1st, 2015.
Got it.
And then it was approved, let's say the Department of Labor was so good that approved it in January 1st, 2016, and immediately thereafter we filed the I-140 petition, and then the Department of Immigration approved your I-140 in February 1st, 2016. It's approved, the I-140. Then your priority date is going to be October 1st, 2015, because was the date the labor certification was filed with the Department of Labor. That's your priority date. That's the day you will go by.
I got it. I understand. A little bit confusing for me.
No worries.
That's what attorneys like you are, in the spectrum. But I understand right now. Just let me recap to see if I understood correctly. Can I?
Yes, please. Go ahead.
Okay. So let's say that my future employer filed the labor certification with the Department of Labor October 1st, 2015.
Yes.
They take like somewhere between 6 to 8 months. That's what I have been reading. Okay?
Yes, and that's correct. I was just giving you crazy days, but yes, they take a little bit.
I like those crazy days. Okay. Okay. So let's say that they my future employer, they file the labor certification, the perm, on October 1st, and everything goes well, and they approve it, and then we file the I-140, and the I-140 is approved. So my priority date would be October 1st.
2015, correct.
2015. So so like the second category for the ED is always current. I mean, it's current right now.
Well, what country are you from?
I'm from Nicaragua.
Nicaragua. And when you say EB2, it's because you are in that category, right?
That's correct.
Yes. Yes. For Nicaragua, you always look at all chargeability areas except those listed, and the ones listed are China, India, Mexico, and Philippines. So yes, Nicaragua will be in the first, all chargeability, and yes, usually they're current. So you're not going to have a priority date. If it stays current, as soon as the labor certification is approved and you're able to file the I-140, you will be able, if the priority date stays current, you will be able to file the I-140 and 485 petitions together, because those petitions can be filed at the same time.
Okay, it sounds very good. My last question is this new method that USCIS is developing. It changed something for me. I mean, it was the same for the last.
I'm sorry. Hello.
My last question is, before this new procedure that is taking place right now, it is something different in my specific situation that is changing right now?
No. In your specific situation, nothing has changed. This benefits more those who traditionally have to wait long times for getting the green card, like China, India, Mexico, Philippines in the third or four other categories, but China and India mainly. Those are the main beneficiaries because now they have a way to file the 485s, even if their priority days, actual priority day is not current. So in your case, Nicaragua, EB2, nothing is changed. You're still in the same.
Got it. Thank you very much. I really appreciate your time. You are doing great. That's a great amount of information. And thank you very much for everything, okay?
Thank you for calling, and thank you for your feedback. We appreciate it.
Okay. Have a great night.
You too.
All right. Caller ending in 5600. Go ahead.
5600, please. Go ahead.
Hi, my name is Mushtaq Bhatt. I am currently on H-1B, and my country of origin is India. So my labor just got approved last week, and I-140 is being filed this week, by the end of this week. So I was wondering, is this new change, with how it is going to affect my status, and my attorney is filing it as a premium processing, and once it gets approved, I-140. So what benefit is going to be with this new change in my case?
Okay. You said your labor certification was just filed, was approved. Do you know when was it filed?
It was filed January 26, 2015.
Okay, so if the I-140 is approved, then your priority date is January 26, 2015, and you said it's an EB2?
EB2, yeah.
Okay. Well, it's good, always is good to premium process the I-140 in terms of that you will have a decision sooner, 15 days. In your case, it may not make a big difference to have a decision in 15 days or in 6 or 8 months, because looking at these priority dates, okay, for India, in the EB2 category for the month of October, the priority date is going to be May 1st, 2005. So you're still, like, based on this, about 10 years away from your priority date to become current. And the filing date is July 1st, 2011. So even if your I-140 is approved in 2 weeks, you won't be able to do anything at all in terms of filing the 485. And I don't know when or how soon January 26, 2015 will become current for filing purposes, since we're going to start with the filing date of July 1st, 2011, and we still don't know how fast this new system is going to be moving. So I think that in terms of having a decision sooner, it's great to do the premium processing, but that's pretty much it. So
yeah, premium processing was done primarily because I'm changing a job, and I have...
Oh, no, then you want to have that I-140 approved.
Exactly. And one more thing, and I don't know, like I heard earlier that if my I-140 is approved, and my wife who is on H4, and can she apply for EAD?
Correct, yes. And that's one of the great changes that happened this year. As of May 26th of this year, spouses in H4 petitions that that are dependents of spouses with I-140 approved petitions can submit the petition for EAD. So as soon as your I-140 is approved, she can file for EAD or I-765 petition. Within 90 days, more or less, you'll have an employment authorization document.
And one last question. This my I-140, is it employer linked, and if I change my job in next 3-4 months, will it get canceled, and will it affect the EAD if approved by then for my wife also?
No. Once she gets the EAD, even if the employer revokes the I-140 that you're going to get approved, then she will keep the EAD. They're not going to revoke her EAD, okay? The problem is going to be that for you, once you change employers, the new employer will need to file labor certification I-140, the whole thing all over again, because you will lose that I-140 that you're getting approved. You will keep your priority date, however, even if the employer later on withdraws that I-140, you will keep your priority date. But you will not be able to use the I-140 to file for 85 if the I-140 was withdrawn, and to get a green card with the new employer, they will have to sponsor you for a new labor certification I-140. Perfect. And for your wife to renew the EAD, then you will have to have a valid I-140 at the time the EAD renewal comes.
Okay, all right. So,
hello?
Yeah, I got it, yeah. Thank you very much.
You're welcome. Good luck.
Thanks a lot.
That's it?
Any other questions? Star 6.
Anybody else? Any other questions?
Star 6.
Star 6.
Ending in 8104.
8104.
Go ahead.
Hello? Go ahead.
8104. Go ahead.
Sorry. Okay. Can you hear me now?
Yes.
I was mute. Hi. I am a green card holder, and I filed I-130 for my wife last month. And the case, the status, it shows that it's received. How long is it going to take? Now, is it supposed to change to initial review? Because it's been more than a month. So it's kind of worried that,
When did you file it?
It was August, the first week of August.
This year?
Yes.
Okay, well, initial review means they receive it. They're reviewing it. Eventually, if they need more information, you might get a request for additional evidence. And if everything is good, then you'll get an approval if they don't need more evidence. So, currently, yes.
The status right now is case received, so that means it's an initial review?
Initial review can last a few months. Currently, the Department of Immigration is taking about 8 to 10 months to go through these I-130 petitions. So you just file in August. It can be an initial review for a few months before you hear from them. So it's okay.
No, right now it says case received.
Case what?
To initial case received.
Okay, they received it. Yeah.
Right. So after that, nothing happens.
Nothing happens, and the website is good to a certain extent because they not always update the websites as things are happening. But yes, case receipt means they got it. It can stay like that for a few months. Then they may say initial review. If they are reviewing it, it may stay like that for a few months. Then if they issue a request for additional evidence, it may stay like that until they updated it again. I would just follow up on the website for processing dates. The Department of Immigration has in their website a chart, or they post information as to how long the different offices are taking in processing certain petitions. So take a look and look for where your petition is pending, and look at processing times and see how long they are taking to process I-140s and go from there. If you see, for example, that at some point they say they're taking 8 months to process I-130s and your I-130 has been pending 10 months, maybe you want to call the Department of Immigration and see what's going on.
Okay, thank you. So now if it's still pending, then I cannot file 485 for her, right? It has to be approved.
You say you are LPR?
Yes.
Okay. LPR, you will have to take a look at the priority date before you can file the 485 for your wife.
Okay.
And the priority date is going to be established on the date the I-130 is approved. If you filed it in August 8, 2015, and the I-130 is approved in October of 2016, the priority date is going to be August 1st, 2015. And if the priority date is current, then you will be able to file the 485. Granted, she's in a status and she's not going to have any problems filing the 485. You will have to look at a few things before filing for 485, making sure she's not going to be affected by filing it if she's not in status at the time you file the 485, okay?
Okay, thank you.
You're welcome. Okay, we have 5 more minutes. We're going to take 2 more questions, and then any questions that we're not able to answer during this phone call, I invite you to please send us an email or call our office and make an appointment to have a consultation with one of our attorneys. So we're taking 2 more phone calls, and we're going to wrap up.
Ending in 90951. Go ahead.
Hello?
Hello, how are you?
I'm doing good. I asked questions earlier. I just needed clarification on something.
Yes, ma'am.
As I told you, actually, me and my husband, we changed the employers 1 year ago, and my employer's I-140 is currently pending, and they're saying that it will probably get approved in November or so. And my husband is on H-1B, but his employer...
I remember you, and that we suggest your premium process your pending I-140.
Right. So you said that my husband can get EAD even without being on H-4. Is that correct?
Well, yes, because that will be based on the I-485 that he will file with you as your dependent. When you file 485, you can file for employment authorization document.
Right, right.
Yep.
But he doesn't have to go on H-4 for that, right?
No, because he will file the 485 based on your green card petition. So if he's in H-1B and he files his 485, he files for employment document, he gets an employment document, he's okay. If he wants to go in H-4, not to lose H status, that's a different thing. But he doesn't have to be in H-4 status to be able to file for employment authorization under the 485.
Okay, good, great. And how long the...
Hello?
Yeah, once we get the EAD, like how long it will be, like when the renewal is?
Usually, let me just, you said you're from India, right?
Yes. So how often
yes. Usually, the EADs for nationals of India, they're issued for 2 years at a time. So his EAD, your EAD might be for 2 years. That's how usually they do it. Normally, EADs are only for 1 year, but because India has such a long waiting list, such a big backlog, they usually do those EADs for 2 years at a time. Now, your husband's other option is just instead of filing 485, which I don't know why he wouldn't file for 485 if he has the opportunity, but he also just file for change of status to H-4, and once he gets his H-4, then he can file for employment document. It's going to take him longer. He might have to start working for some time until the EAD is approved after he gets the H-4, but he could do it that way, or just file for 485 and get the EAD.
Get the EAD, okay.
But he will not have status to start using the EAD.
And it will not affect his work status, right? He can still work.
Yes, based on the EAD.
Okay.
Or if he decides use the EAD and continues to use the H4, the H1B, then it's fine.
Okay. All right.
Great.
Thank you very much. It was great information.
Thank you. One more question and we'll be done for today. Again, if we don't get to you, please feel free to email us or call us for a telephone conference.
Last question, ending in 688. Go ahead.
Hello?
Yes. Go ahead.
Can you hear me? Yeah, hi. My question is, I'm on a J1 waiver. I'm on an H1B right now, and I started my waiver job almost close to a year ago. It's going to be a year on October 16th. My lawyer has filed for a labor certification as well as a national interest waiver on my behalf, and my husband is a dependent on it. So how is this new process going to benefit to any of my advantage? Is it even going to help? Am I going to be able to go for a I-485 petition this October or not? And how does it both differentiate if it's a national interest waiver versus a labor certification?
Okay. When was the, okay, there's a few things here, and I'm going to try to make it simple, not to get anybody confused, or you for that effect, because it's there's a bunch of different issues that we'll have to look at. But in general, okay, you started to work on your J1 waiver, in compliance of your J1 waiver about a year ago, correct?
Yes.
Okay. So, depending as to what was filed first, the national interest waiver or the labor certification?
The labor certification was done this year in January, and the national interest waiver was completed in April.
Okay, so what will happen is that, let's assume if both of those processes are approved, then your priority day is going to be the earliest one, which is going to be January 2015. Okay, and that's the priority that you want to use to make sure you keep in front of you. Mm-hmm. Regardless of whichever gets approved first, your priority date is going to be, you want to use the earliest priority date, January 2015. Okay?
Mm-hmm.
Now, in terms of the latest changes for you right now, well, they really don't benefit you. It might benefit you in a few months if the filing priority date continue to move forward. You might be able to file for your 485s based upon the labor certification before you complete the 3 years of your J1 waiver. Okay. One of the premises is that if you are subject to the 3-year obligation of the J1 waiver, then you can't file an I-485 until you complete the 3 years. An exception is for national interest waiver petitions, where even if you have not completed the 3 years, you can file the I-485 petitions. Because remember, national interest waiver, you're subject to complete in 5 years before they give you a green card.
Right.
So your husband, as your dependent, can file I-485s with you whenever, either as soon as the filing date becomes current under the national interest waiver, or if at the time the filing date, priority filing date becomes current, you already completed the 3 years, then I will file the 485 under either the labor certification or the national. I would file it probably under the national interest waiver, but adjust or get the green card through the labor certification if the priority date, the actual priority date, becomes current sooner. Because you want to get your green card before 5 years if you can, but if not, well, get it through the process that is more convenient to you. What that means is if you complete the 5 years of your national interest waiver and you're still waiting for the priority date to become current, but you have the I-485 filed, then you would not have to worry about having your employer's sponsorship, because if you file your 485 under the national interest waiver, you are completed with your 5 years, and then you can take the process with you. There's different things that you need to look at, but right now I think you're doing fine. What will determine when and how you file the 485 is whether the filing date becomes current before you complete the 3 years. If it is before you complete the 3 years, then you will be looking at the national interest waiver to file the 485. If it is available after you complete the 3 years, then you can look at either the LC or the NIW to file the 485, and that's for you to think about how you want to complete your process going forward.
But I have one confusion here. What if the priority date does not become current in the next 3 years, even if I finish my waiver? So what happens at that point? What should I defer at that point, the labor certification process or the NIW? I mean, it's a little confusing because as of now, the current priority date for India, which I'm from, is May 2005, and my filing was done in 2015. So if the current date, priority date, doesn't become current in the next 3 years, what's the next step?
Okay, well, let me just tell you, there is very likely that the priority date is not going to become current, that you will complete your 3 years and the priority date is still going to be backlogged.
Right.
I mean, I could say almost 99.9% that is not going to be current. At that point, if you want to change employers, then you might want to be looking at the national interest waiver. That is a process that you can take with you anywhere. Go to another underserved area to complete the 2 years that will be left on your 5-year NIW obligation. Or if you don't want to work in an underserved area anymore, then you can go to another employer for them to sponsor your LC I-140 again, because if the priority date doesn't become current, if you're not able to file the 485 and have it pending for 6 months, when you change employers, you're going to lose that labor certification I-140 that you're going to get through this employer. So it is a matter of understanding where you will be in the green card process and what your goals are. I can tell you for a fact that many of the physicians that I work with, many times they obtain, even if they file the labor certification and the national interest waiver, they obtain the green cards through the national interest waiver, because many times they do complete the 5 years of services in the underserved area, and they are still waiting for the priority date to become current. So once they complete the 5 years, they can work anywhere they want to. They'll have already met the requirement, and all they'll be waiting is for the priority date to become current, for the USCIS to take note that they completed the 5 years and just give them the green card, even if it is 7 years or 1 or 2 years after they completed the 5 years.
Okay. So,
I mean, to you.
Yeah, I'm sorry, go ahead.
The NIW belongs to you, the LC belongs to the employer. That's a big difference.
So in your experience, you have worked with physicians before who have even applied for a national interest waiver. I'm currently with my same employer for my NIW also for the next 5 years. Say even after the next 5 years, the priority date doesn't become current. Usually in your experience, how much time does it take after you've completed the 5-year obligation for NIW to get the green card?
For people from India, we've seen 6 to 7 years for people to get their green cards. Is a kind of an average because of the priority date issue.
Right. But does it change if you have applied it via NIW, because instead of doing 3 years, you're doing 5 years in an underserved area? Does that help any, or it really doesn't?
The priority date system doesn't change because of the basis of your green card application. So you can apply for green cards through the labor certification, through the national interest waiver, through any of those options, and the priority date system is the same. So it doesn't go by NIWLC, it goes by dates that the Department of Immigration has available to grant visas. For India, the backlog is huge, whether it's an NIW or LC.
So what's the difference in doing it via both the processes? My lawyer gave me an impression that you can do it in a parallel process. You can do the labor certification along with the NIW, because there are sometimes it's quite likely that the NIW might work faster than the labor certification.
That's the difference. Mainly, you do both processes to have a backup plan. It's like plan B. And if the priority date becomes current before you do the 5 years in NIW, then you use DLC to get the green card faster. But if not, then you can use either one if you're still with the same employer. I haven't had many cases where the priority date is current before the NIW 5 years is completed. But it's more a backup plan than anything else.
Okay. Okay, thank you so much. We appreciate it. Thanks for your help. Thank you.
Thank you. My pleasure. Well, this is our last call. We apologize to all of those who are still in queue, but please feel free to send us an email with your questions. My email is alopez@cowlesthompson.com, or call us at 214-672-2162 and make an appointment to speak with one of our lawyers. We'll be happy to help you. We hope to continue to be able to have these telephone conferences to give you good news about changes in immigration that are going to help us to get our green cards or any other benefits sooner. We appreciate your attendance today. Please stay in touch, and thank you. Have a good afternoon.